The content of the following program, including all statements from the hosts and guests, is to provide general information and commentary about the law. Under no circumstances does any statement made by the host or guest to a caller or listener constitute legal advice or the formation of an attorney-client relationship, and the material from this program shall not be viewed as substitute for a personal consultation with an attorney. Now, prepare yourself to be informed and entertained by Gus Bravo and Neil Kotze, two AV-rated trial lawyers who have been practicing law for a combined total of nearly 40 years. For the next 30 minutes, they will share their insight and commentary on important legal issues affecting all of us.
The National Institutes of Health have now announced that they will no longer be using rats for medical experimentation. In their place, they will use attorneys instead. They've given 3 reasons for this new policy determination. 1, there are now more attorneys than there are rats. 2, the medical researchers just don't become as emotionally attached to the attorneys as they did to the rats. And 3, no matter how hard you try, there are some things that rats just won't do. I'm Neil Kotze. Welcome to Attorney Confidential with Gus and Neil.
And I'm Gus Bravo. Thank you for that, Neil. It's not bad, the fact that you were 5 minutes late.
Yes, I apologize. At traffic, I got a little stuck. So,
and the problem is I can't start without you because you're the one that has the jokes.
I do the opening joke. So for those of you that were just dying to wait for us to start at 6 o'clock and we're a few minutes late.
He's the guy to blame.
I was running on Jewish Standard Time. So actually I'm still 5 minutes early by that definition. But yes, I did get here a little late.
You know, I grew up playing with a lot of Jamaicans, so I don't want to offend people about being on time to things. But in any event, thank you, Neil, for the joke. And you're listening to Attorney Confidential with Gus and Neil. For those of you that want to call in, last week the koozies, the free koozies, were a big hit. So, Neil, I don't know if you have any more koozies.
The Kotze koozies?
Yeah, say that 3 times really fast. But if you have any more available, whoever is our first caller, 888-565-1470, will not only get a 30-minute free consultation with the one and only Mr. Neil Kotze, but more importantly, I think,
free koozie
and more valuable
to keep your drink right.
Exactly.
More valuable, really? Oh, yeah,
how's that for a sales job? You'll get a free koozie. So 888-565-1470. Neil, before we get to our headlines or legal headlines, this weekend was another huge sports weekend. I love the summers because we have the NBA Finals ending, U.S. Open Cup. First, I have to thank again the Golden State Warriors for winning the NBA Finals. I'm more happy about the fact that Cleveland lost than actually Golden State won. But nonetheless, I think it would have been very, very difficult for most of us Miami Heat fans to have witnessed LeBron winning after he left us.
The guy goes home to play with his home team, and it's amazing to me how people get upset over that.
No, he had it planned all along. I'm upset because he knew this all along, and he played Pat Riley. I won't get into the specifics, but had him fly out to Vegas, prevented the Heat from making some movements in the offseason when he knew he wasn't going to be returning. But I digress. The U.S. Open Cup Finals, the golf championship. Did you have to watch that?
Oh, my gosh. What a great finish and a sad finish.
Terrible. Felt so bad. For those of you who weren't watching, you had Jordan Spieth, who's the new Wonder King. He's the 20-year-old. I think he's just 20. He won the Masters going away, and he was leading the U.S. Open by 1 shot, but with one final group to play. Dustin Johnson, right?
Pulled a John Vandervelde.
Yes,
remember John,
the British Open. I'm very impressed.
John Vandervelde.
Yeah, it wasn't quite as bad, though. No. John Vandervelde was bad. He was leading, and he kind of gave away at the last hole. So Dustin Johnson literally had a chance. He had a putt to win for Eagle to win the U.S. Open, and he was about 12 feet away. It's not by no stretch a gimme. Not only he ended up missing that putt, but he ended up missing the birdie putt coming back. So
if you watch the replay, for those of you that play golf, though, if you watch how lightly he tapped that eagle putt and it still rolled that far by the hole. So there's not much he could have done other than make the eagle putt to give himself a shorter putt for birdie. But the problem is he just walked up and putted the birdie putt. He didn't take any time. He didn't go to the other side of the hole to look at the break again.
Well, it's such a mental game. I was watching it with my son, and I said, The problem, he went from almost winning it to losing it in a span of 3 minutes. And that's just, it's so tough. I mean, he could make that putt 100 times over, but when all the chips are on the table. And actually, I didn't realize it, but he's married to Wayne Gretzky's daughter.
Oh, I didn't know that.
Gretzky was there with his wife and everything. So anyways, it was just difficult to see that. But to me, what was comforting was on his walk back to the clubhouse, picked up his kid, Father's Day, and that kind of seemed to, put things in perspective. So, by the way, belated Happy Father's Day to you.
To you as well.
Thank you.
And to our fathers.
Absolutely. I know yours is watching. Mine, we'll see. Anyways, legal headlines, because we kind of have to rush through since, someone was late here today. But legal headlines, what do you have here for us today?
Well, we had a couple of interesting cases that have come out. Why don't I start with, because we tend to talk a lot about, we've been talking about employment and the personal injury cases, and one of the other areas that we practice in and we love is the intellectual property. And Google took a hit in the Supreme Court. For those of you that use the Street View navigation service, Google was sued. And this case will give us some examples of a lot of things we've talked about.
Street View, you're talking about when you go on Google Maps and you can get the Street View?
They were sued by, and I've got the caption. I didn't go to Wikipedia. For those of you, this is the actual court caption, because Gus will never let me live that down.
I'm sure it's Wikipedia. That's the pages 4 through 7. Yeah. Just in case, a little summary.
Exactly. Videri LLC versus Google. But again, we've talked about how long litigation takes. Videri actually sued Google in California in 2010, the trial was. Then they go up on appeal to the Federal Circuit, which is the Circuit Court of Appeals that handles all patent cases. The Court of Appeals ruled that Google basically won in the lower court. The Court of Appeals reversed.
Right.
And then they go up to the Supreme Court.
But what was the issue?
The issue was Videri designed the actual software and program for this for the mapping issue, for the Street View navigation issue.
Okay.
And so you had to look at their claims and how narrow their claims were within the patent. Now, I don't want to bore everybody with doing patent interpretation. I get no.
I'm sorry, that was a sleeping noise that I just made.
But the interesting issue in this case is it shows a couple of things. Again, it reminds people that litigation is a lengthy process.
Yes.
The case, again, goes to trial in 2010. What's happening now, which is interesting, is in 2010, the trial court granted what's called summary judgment for Google. So it never made it to a jury. What's happening now is that
get kicked back,
and we're going to have a jury trial sometime
and then you'll have an appeal of that decision.
In 2016 or 2017. Right. It'll finally go to a jury, then it'll go up on appeal. So you're looking at 2020.
So this is a patent infringement case.
Correct.
But
Videri had a patent for this navigation system, the street map system.
Right.
They claim that Google Maps basically infringes on that patent. Interestingly enough, too, the U.S. Supreme Court, which shows the balance of powers between the judicial branch and the executive branch, actually asked the Solicitor General of the United States to file an amicus brief telling the Supreme Court what the president's position was.
What does amicus stand for?
Friend of the court.
Very good.
Thank you, Mom and Dad, for forcing me to take Latin. Now,
this is the one time it comes in handy.
In 25 years of practicing law, somebody finally asks me a question that requires me to relate back to my Latin training. Amicus is a friend of the court.
So, you had an intellectual property case. I actually have another one, similar to one. It's the case of Spider-Man. I think mine's going to be a little bit more interesting.
You know that he is that's the only Jewish superhero, Spider-Man.
Really?
If you pronounce it Spider-Man.
I was for it, Neil. I thought maybe the creator and stuff. Okay. We're trying to be serious here.
I'm sorry. Go ahead.
So anyways, there was a recent Supreme Court decision. It actually came out, I think, today. It's Kimball versus Marvel Entertainment. So what happened was Marvel, who was, I guess, or Marvel, I guess. I don't know how you would pronounce Marvel.
Marvel Comics?
Yes.
Yeah.
Had paid was paying a royalty to this gentleman by the name of Kimball, who had designed the first spider toy. And so we have here an opinion because one of the Supreme Court's justices, Kagan, just could not resist the urge in the opinion to quote portions from the comic book. So here what we have up on the screen is a quote from the opinion which says, "What we can decide, we can undecide. But stare decisis teaches us that we should exercise that authority sparingly." Then, citing Spider-Man, I guess the 1962 Amazing Fantasy number 15 says, "In this world with great power, there must also come great responsibility." And she continued. There's actually another one that we have up. If we can come up in a second, yes. Judge Kagan continued, said, "The parties set no end date for royalties, apparently contemplating that they would continue for as long as kids want to imitate Spider-Man, in parentheses, by doing whatever a spider can," which I thought was great. The ruling ended up becoming that the royalties, the payment for the royalties that Marvel was making to this gentleman Kimball, ceased at the moment that his patent expired, which was in 2010. And they based it on some 1962 decision, basically said, you can't continue after the patent. So you can imagine the amount of money that could mean. Supposedly a bad decision, but regardless of the opinion, to me what was fascinating as a judge, this is an example of very creative writing.
Oh, I mean, judges can get cute with their writing. I remember an opinion I had many years ago in a class action case. There's different levels of class action cases. There's B2 classes, B3 classes. We were trying to certify as a B2 class. And the opinion from the appellate court started out with the following quote, "B2 or not B2?" That is the question. So judges can be humorous when they choose to be.
And I think that is a perfect breaking point because, believe it or not, Neil,
we
are now reached the halfway point.
Because someone was late.
I'm not going to say it, but anyway, hopefully the second half we'll have a little bit more, and you won't take a bathroom break and be late for the second half of the show.
No, I promise.
Just making sure. But call us 888-565-1470. The second half of the show, we're going to be talking about other legal headlines and any other questions we may get from callers. You're listening to Attorney Confidential with Gus and Neil.
Attorney Confidential with Gus and Neil is being brought to you by the law offices of Neil D. Codsey and Bravo Law. Bravo Law is a business litigation firm known for providing common sense solutions to small businesses and individuals throughout South Florida. Mr. Bravo is rated AV by Martindale-Hubbell and Superb by AVVO, the highest ratings available from these two entities. The law offices of Neil D. Codsey is a litigation boutique with offices in Broward and Miami-Dade counties. Mr. Codsey is a veteran trial lawyer with nearly 25 years of jury trial experience. He is also a two-time recipient of the South Florida Daily Business Review's Most Effective Lawyer Award, a recipient of numerous awards for providing pro bono legal services, and has been recognized by the National Law Council. Call our office, 786-464-0841 or 954-790-6711 and get informed. You're listening to Attorney Confidential with Gus and Neil. If you have a comment, question, or just want to contribute to the conversation, call the show at 888-565-1470 and share your thoughts on what's going on. Now, back to Gus and Neil for more Attorney Confidential.
And we're back with Attorney Confidential with Gus and Neil. Gus, who's on time, and Neil Codsey, who was 5 minutes late.
Well, you know what?
I am going to beat this horse.
Maybe I should be happy. Now, this will take place of the age jokes that I'm used to seeing, so it will just go
It
with
won't be in lieu of.
It'll be in addition to.
Absolutely. Well, we've been
Please call 1-888-565-1470.
And tell us about the story the last time you were late to a very important event. So we've been talking about legal headlines. I have one. I know you got another one, but let me take a stab at this one. The FCC, Federal Communications Commission, fined recently AT&T $100 million because it was, quote, misleading its customers about unlimited mobile data plans, end quote. Now, as an AT&T customer, I can tell you, I was thrilled to hear that.
My mobile plan now.
It gets into some specifics, but here's the AT&T picture that I found. Now, this was done unintentionally, but I think it serves of a good purpose. The picture that's up on the screen is a logo of AT&T, and it says "Your World Delivered."
This is the third,
and then it says "Straight to the NSA."
And now the third show in a row we've talked about balls because there's the AT&T ball logo. So we have another theme resonating.
That's a sphere, Neil.
I'm going to let that one go. Let's just pass on that.
So, anyways, back on point. AT&T. The picture that came up was actually what happens when I did a search for AT&T, but again, under the Google Images search, it had to be the ones that's free for commercial use, and that's the only AT&T logo that came up. So sometimes, as a company, you may want to control what logos you actually reveal out there. You may want to allow people to have a commercial use of a logo, because otherwise, this is what's going to come up. But anyways, AT&T gets fined $100 million for misleading customers about unlimited mobile data plans, which I think is very. I think it's a very important decision because we're now getting into the digital age. I know it's shocking. The internets and logging into Google and all this discussion may be a little bit ahead of your time, but
I'm just letting this go because I know if I fight back, I'm going to be criticized for being late again.
But I think it's important because, look, I'm an AT&T customer, and my wife and I, we actually had unlimited data plan for years, and that's one of the ways they kept us on there. And they said you're grandfathered in, and so we always resisted the urge of moving to other plans because we had unlimited data. And so eventually the monthly sum that we're paying just became too high. And I said, well, if you can undo the unlimited data, then here are some other plans much more economical. Of course, then here comes my soon-to-be teenage son with his iPhone, and the data plan just completely blows up. And so the funny thing is my son lost his phone about a month and a half ago, and we've used basically 30% of our data plan, which we haven't done in months.
Well,
in years, probably.
Right, that's kind of like the credit card joke I did last week.
It is, which I'm sure went over really well at home.
Not at all. The couch, by the way, I am here to report that our couch is actually quite comfortable.
Well, I'm glad to see you're sitting here.
Right.
Is that the reason you were late?
Oh,
all right, why don't we turn to your story?
Well,
your headline.
Well, the headline,
if
we
you
want to do
have
the AVO questions, because I was thinking I might go, we can go back to the headline, but this was an interesting point. Again, we've been talking about questions that people ask on AVO, and one I've gotten this question a lot, and I thought this was a good one to share for people that are worried about insurance issues. This is a question from someone who was involved in an accident, and they asked, can the person who was at fault in a car accident with bodily injury change his policy 4 days after the accident? Because what happened was the person that was in the accident had a $250,000 policy, and then after the accident they went and bought a $10,000 policy thinking...
I'm shaking my head.
I know
no.
you are. And the answer is very straightforward.
As in, I know I can't believe they were doing that, and no, they can't.
Exactly. I mean,
it's not going to have
the
any
policy
effect.
limit. So when you get this is for people who might think of doing that if they're in an accident, or people who might get concerned if
or you may try to get more insurance because you think you're going to be able to get covered.
The insurance in place at the time of the accident is the insurance that's in place.
There's the two types. There's the what in place at the time, and then also when the date of loss. It really depends. You can actually get coverage that covers you.
Well, that's true. If you're dealing with a car accident, those are usually on the same day, but there are going to be other, like you and I have some construction litigation cases in which the construction begins in January 1st and continues until November, let's say. And
Rest
then you've
assured, when the insurance company is willing to insure you for the time period of whatever claims, it's the claims made versus claims occurred.
Yeah.
And so when it's claims made, obviously during that time period, they're gonna charge you a higher premium because they don't know what's behind door number 2 or door number 1 for that matter. So they'll charge you a higher premium.
And you changing your insurance in an automobile situation is really not going to affect
But you're
anything.
right, in a car scenario, no.
The car scenario is pretty straightforward. So I thought that was an interesting one that you see that every now and then. We've had people ask us that. So that was one that...
And that, by the way, maybe it's think about it later on, trying to argue in front of a jury and saying, well, what did you do 4 days later?
Yeah, that doesn't help. And then my humorous one. That was actually a substantive one for anybody, and we could, if somebody wants to call and ask more about that, but I think we've gotten the gist of the insurance issue. This is a question: are schools above the law?
When you put it that way.
I am a middle schooler, and it just irritates me when teachers do this. For example, teachers take students' property without consent. I have some more examples, but I can't think of any right now. So a middle schooler logs on to AVO. I'm going to start with the first answer, which will tell you what people thought of this question. The first answer is, you posted your question in the brain injury category. This is not a brain injury.
Well, maybe.
That's what I thought. Maybe it is.
Are you so sure?
You may be better served to post this question in its proper category. Now, then there are a couple of lawyers that go, well, you might want to consult with a lawyer, which I always get a kick out of, because those lawyers don't read the question. It's a classic example of...
No, they have their stock response. You may want to consult with a lawyer, and here's my contact information.
Exactly. And you've got a middle schooler now asking if his teachers are above the law. My favorite, though, is... And I'm going to call out Mark Tischnauzer from Tampa, Florida, because it's just a great answer. While teachers are not above the law, neither are you. And as such, middle school children have no business on the internet seeking legal advice.
Wow. Sounds like a parent.
Yeah. For a variety of reasons, starting with the fact that you are not a legal adult. If you have such an issue, discuss this with your parents, and they will handle things as they feel are appropriate.
You know what? I disagree. I think my initial thought when you said that, I thought, well, you know what? Good for him or her. I don't know if it was a boy or girl. Unless it was my son.
I can't reveal the name because that would be violating the minor.
But good for that middle schooler. You go on there. There's a lot of worse things they could be doing online. Believe me.
That's an interesting point.
And so to educate themselves, they're asking and frankly, you have read some questions that were awful, right? I mean, and so this is at least, you know what? It's a valid question. Can a teacher take away my property without my consent?
And now that you say that, I'll change my tune a little bit. I think you're right. It's interesting for
I
middle
wouldn't chastise that kid at all. I think it's a good thing that he or she is taking the time to try to educate themselves about their legal rights. They do have legal rights.
To log into AVO, to take the time to get on the internet and to log into AVO to ask what they believe might be a legitimate legal question is not an abuse of the internet as opposed to some of the other things that a middle schooler might do on the internet.
Absolutely.
I won't disagree.
There would be worse things. If that were my son, I'd say, well, why don't you ask me first? But aside from that, I think it's illicit. It could be worse things you could be doing. Educate yourself on it. And I think we should...
So if any middle schoolers out there want to call in to ask...
888-565-1470. You could also tweet us, Bravo_.
But can I give a middle schooler a free koozie? I'm not sure I want to go that route. You can use it for soda.
Yeah, of course. What else would you use it for?
Yeah, exactly. What else would a middle schooler use it for?
Well, you know, it's funny that the fact that there were some serious questions and some obviously funny answers. It looks like we have 2 minutes left, but it reminded me. I was having a discussion earlier with somebody and telling them about the radio show, and they said, you know, you may want to consider not trying to be so funny because, you know, lawyers are supposed to be serious, and, you know, people come to you for serious things. And so they may not want to associate themselves with something that's, you know, serious, and then you guys are being funny. I said, you know what? That's a valid point. But at the same time, we want to show at least, I think, not a humorous, but the law can be entertaining. The law has a lot of different areas and faces to it, right? And we are, I like to think of ourselves as funny guys, and we happen to be funny guys who happen to be lawyers. So clearly, we're not going to be the court jesters, and I think you mentioned this on one of your earlier shows.
Exactly. The role is to lawyers are people too, and I do agree that you don't want to get to the point where you're nothing but the court jester.
Right. So we have 1 minute left, so you got 30 seconds for your takeaway. Let's give you 25.
Never ever show up late to a radio show when you're co-hosting it with someone who is going to rattle you about it for the rest of the show.
Very good advice.
That is very good advice. Other than that, I will pass the baton back to you for your quote and thought of the day.
Perfect. I think we should have a picture coming up soon. And he say Bueller, right? There it is. I love this one. It says, what others think is not important. How you feel about yourself is all what matters. And for those of you listening, there's a picture of a little boy with a cape and boots on. So, Neil, what I say shouldn't matter. The fact that you were late and irresponsible.
Did my parents give you that picture of me? I'm trying to figure out where you found it.
Hopefully that's not you. Anyways, tune in again next week to Attorney Confidential with Gus and Neil. Hopefully, Neil, you'll be on time.
I'll be on time. I'm going to try to be 5 minutes early.
You have been listening to Attorney Confidential with Gus Bravo and Neil Kotze, two rated AV trial attorneys with over 40 years of experience. Tune in next week for another episode of entertainment, insight, and just plain fun. That's Monday, 6 p.m. on WNN, 1470 AM. See you next Monday for more Attorney Confidential. The opinions expressed on the preceding sponsored program